joining this CLE presentation on keys to successful Microsoft negotiations. My name is Robert Scott. I'm the managing partner of Scott & Scott LLP, located in Southlake, Texas. And I'd like to start the presentation by talking about the types of legal engagements that attorneys are facing in terms of Microsoft transactions and disputes, and to talk about the categories of matters that we're involved with on a regular basis. In our large client base, we see a lot of engagements around Microsoft's enterprise agreements and its various iterations, including what they refer to as EA enrollments, which would be a new initiation of an enterprise license agreement. And those enterprise license agreements are typically very favorable for large global companies and start at approximately 500 computer user environments and extend up all the way to the largest companies in the world. And our role in dealing with those transactions is to assist the client in evaluating the appropriate type of enrollments, the appropriate counts, and negotiating the business terms around a specific contract with Microsoft. These enrollments typically involve all of the desktop environments and frequently involve many of the server environments, and so they can be very comprehensive and in many instances involve significant dollar amounts both for the end user and for Microsoft. As part of those agreements, which are typically 3-year terms, they involve an annual true-up obligation, which is a voluntary license investigation and reconciliation that involves a purchase that comes at the end of that process and happens on an annual basis. And in addition, after an initial EA term, there are frequently negotiations regarding renewals for additional terms, and those engagements can be pretty significant in terms of the types of issues, legal issues that arise and the negotiations involved in those renewals. An area that has really grown in terms of legal engagements involving Microsoft is in the context of the Service Provider License Agreement. Many of you may understand that by a common acronym called SPLA or SPLA. This is a type of Microsoft partnership arrangement where an end user is entitled to resell certain licenses for hosting or commercial hosting rights, and has become a very hot issue both in light of the growth of outsourced IT services, hosting, and cloud on the one hand, and the fact that many large enterprise clients that typically buy under EA or perpetual licenses have aspects of their business that involve commercial hosting, which under certain circumstances would need to be licensed under a service provider license agreement. So we see SPLA as a very hot area, and we'll get into that in a little bit more detail later. Another type of engagement that comes up is a client is concerned about their license status with Microsoft, either in a particular geographic area or on a global basis, and they ask a lawyer to assist with conducting a review of all of their license deployments and their entitlements and prepare an investigation that shows what the compliance gaps may be and make recommendations for remediating any of those gaps through a combination typically of buying additional licenses or uninstalling licenses that may have been deployed without permission or that may not have been remediated properly after they have discontinued use. We also see a number of issues with Microsoft licensing in connection with our clients' M&A activity. So that would be business acquisitions, asset acquisitions that involve computer assets, and business divestitures. In many instances, a number of legal issues and disputes can arise regarding transferability of those licenses, as well as liability for compliance issues that may have arose prior to the transaction, and relative indemnity obligations between the parties with respect to those. We also see a lot of questions, particularly in our larger clients, about affiliate enrollment into enterprise-type agreements, and we see a trend within our large clients toward global sourcing or single sourcing in terms of corporate procurement being concentrated in a particular area, and this issue of which affiliates, particularly on an international basis, will come up, and that's an issue that is frequently part of the negotiations in terms of transactions, particularly in the enterprise level clients. A lot of what we do as well is basic interpretation and counseling regarding Microsoft's licensing. For those of you who are unfamiliar with Microsoft's licensing rules, they tend to be very complex. They involve a number of frequently highly technical issues, including issues involving data centers and access. And so we spend a lot of time just counseling clients on the rules regarding what they can and can't do with their Microsoft software and with assistance in interpreting the licenses. One of the things that we're seeing a lot of in terms of trends with our Microsoft matters is one of the hot issues that we're seeing right now is the changes to SQL Server licensing. And the net effect of that is really that SQL Server is becoming more expensive over time for most customers. And the importance of software assurance, which is listed here as SA, you'll see a number of acronyms throughout the Microsoft licensing world, and I'll try to cover those. On this slide, SA stands for software assurance, which is another way that Microsoft describes its maintenance. And then EA stands for enterprise agreements. And what we're seeing with these new licensing changes for SQL is a change in the way the processors are going to be counted from a per processor to a per core licensing. And if you think about large database servers, the trend is toward multi-processor, multi-core. And in the beefier sort of enterprise deployments, we're talking about ratios of cores to processors being significantly higher than 1-to-1, mainly that the number of cores is greatly higher than the number of processors, and therefore the change can actually become more expensive in those environments where you have a large number of cores. The other thing to think about with regard to virtualization, which we see as a common trend among almost all of our clients, is the role of software assurance and its requirement from the perspective of having unlimited virtualization rights. And so we see a lot of our clients looking at these recent changes to SQL and evaluating how those changes will affect them as they go forward. And one of the areas that they're considering is a new enterprise application for platforms under an enterprise agreement, which it goes by the acronym of EAP, which is a relatively new program that's being offered by Microsoft that has become very hot of late, in my opinion, in particular in light of the changes to the SQL Server pricing. And what the EA enrollment offers is an enterprise estate-based enrollment for server products, including SQL and SharePoint, and the ability to really to place a high degree of certainty on what your server licensing costs will be across an enterprise. And as a result of agreeing to the all or nothing approach to enrollment, what you're getting is a significant price concession from Microsoft with regard to the EAP. I have advised many of my clients to strongly consider the EAP in light of the SQL Server changes in price because there's a number of factors, particularly for global organizations, where the savings can be very significant, and for those companies that truly are working towards an enterprise platform for Microsoft, the EAP, in my opinion, plays nicely with existing enterprise agreements, and in my opinion, all enterprise agreement customers should be strongly considering whether or not EAP and particularly which term of EAP might be of benefit to them. One of the other big trends that we're seeing is Microsoft really trying to place more value on the software assurance benefits. And what we're seeing, the exclusive rights that you get from software assurance becoming more and more valuable depending on a client situation. I mentioned earlier the issue of hosting and how many enterprise clients are now engaged in deploying Microsoft technologies in commercial ways such that their clients, non-employees, independent contractors are accessing directly or indirectly Microsoft technologies, and in a way that Microsoft would claim that a regular client access license would not be sufficient. And so we have a number of clients that are looking at software assurance and saying, do I want to use software assurance to cover my hosting environments, or do I want to go with SPLA or the service provider license agreement to cover those environments? And this, I would say, commercial hosting is probably the hottest topic that we're seeing in terms of recent trends, because it is being triggered both by the trend towards outsourcing and cloud-based services on the one hand, in terms of service provider partners, as well as enterprise customers that are engaging in deployment of technologies, for example, customer-facing applications for which a client access license would not be appropriate. Through all these types of transactions and disputes that we're involved in, we've identified a list of success factors that we see where our clients are getting very favorable outcomes in negotiations with Microsoft. We see that these common factors are present. By implication, the absence of any of these factors would be an indication that you might have a lack of success in the negotiation. I would say first and foremost, the number one thing that I see with someone who's struggling with Microsoft is that they really don't understand what software they have deployed down to the specific products and the specific counts, and what software they have entitlements for. In other words, what records do they have that would be considered acceptable to Microsoft or a third party that's acting on their behalf that would constitute legal proof of entitlement. And so they wind up in a situation where they really can't proceed with negotiations because they don't have a clear understanding of the facts that would be relevant to that negotiation. And I think that, first and foremost, is a critical success factor. In addition, we see a number of clients that don't really have an understanding of how the technology is being used in a particular environment and what those use characterizations may mean for purposes of licensing compliance under the applicable Microsoft agreement. I used the example of service provider access. That's one where we see the nature of the client access license that's required is frequently a challenge for our clients in terms of understanding how the software is being used. Other use characterizations that become critically important in Microsoft analysis include developer licenses, so that would be licenses that are not being used in a production environment, disaster recovery type licenses, failover type licenses, commercial licenses versus non-commercial. All of these use characterizations become very important to understanding. Once you have the raw counts, massaging those counts to understand, based on the use characterization, how the counts can be correlated to the licensing rules. The other thing that we see is that in many instances, the clients are in the wrong licensing model. And I counsel my clients a lot that if you're a large global enterprise and you're buying OEM licenses from your hardware reseller, and you're buying under an open volume license for other products, and your licensing is decentralized around the world, from Microsoft's perspective, you're not in the right model. And as in light of that, it could affect the success of your negotiations with Microsoft. If they see you in your peer group as being appropriate for a particular type of model, and you have decided that that model doesn't fit for you, then in my experience, that would be an example where disputes can arise. So for example, large enterprise clients that are rolling off of EAs and not renewing, I've seen in my experience a trend where some of those clients will be audited shortly after the renewal time period passes, and so that to me is a symptom of this appropriate licensing model question, where it's important to understand what models are available, how they've been constructed, who they've been designed to appeal to, and how a particular client fits within that schema. The other thing that we see is a lack of alignment within an organization between the legal teams, the business teams, and the IT teams about where to go with regard to Microsoft licensing, how to approach a negotiation with Microsoft, and that lack of alignment causes, in my opinion, a lack of success in terms of the negotiation. In my experience, the companies that do the best in terms of their negotiations have clear alignment, clear lines of communication and cooperation between all facets, including legal, business, technology, procurement, etc. Microsoft, in a large enterprise arrangement, is going to have a team of professionals working on the client engagement, and the clients that are capable of bringing the appropriate resources to bear, in my experience, have the best outcomes. The other aspect is to clearly define your business objectives. You know, if your business objectives are to have flexibility to float down in the types of licenses that you want to buy because you're planning to have a potential reduction in force or a divestiture of a business unit, your licensing needs will be different than a customer whose growth trajectory in terms of desktop count and software utilization is projected to increase significantly over time. And so having a clearly defined set of objectives and plans, what you want to achieve with regard to your negotiations or transactions with Microsoft, is another critical success factor that we see. The other one that we see a lot is just a complete and utter failure to understand Microsoft's perspective in terms of the situation. I see many clients who get into a situation with Microsoft and feel that they're not treating them as a business partner, that they're not giving them appropriate credit for how large of a customer they are, or otherwise are engaging in business tactics in connection with a dispute that they don't think is appropriate. In my experience, Microsoft's perspective is one that they want to treat all of their customers equally, that their rules are out there and are available to the customer, and every customer should be on equal footing with regard to compliance. And the analysis of a client's license position and the effect of how to deal with any compliance gaps is a matter of contract. in many instances, and therefore not subject to extensive negotiation on a one-off basis, that they're entitled to be paid for their intellectual property, and that if a client is out of compliance, that they should pay an appropriate amount of money that would be consistent with what their other customers of similar size, industry, etc. are paying. I have generally found that Microsoft's approach to transactions and disputes is very dispassionate. They're not typically emotionally tied to a particular outcome. They have, very experienced professionals working on these matters, and for them, it's part of their business objectives and assignments to work with the customers to work through these transactions and disputes. And I think having an understanding of their perspective is very helpful. One of the things that I encounter when dealing with Microsoft is that their urgency to resolve a particular matter is typically higher than the client's urgency. And so what I frequently am in the position of doing is helping my clients understand the timing expectations and considerations of Microsoft when dealing with transactions and disputes. And one of the things that I like to advise my clients about is that there are certain time periods where Microsoft gets particularly aggressive in terms of their negotiations based on business priorities that they've set internally. And historically, one of those time periods where Microsoft is eager to get deals done is around their fiscal year end that ends June 30. So in my practice, we find that we're doing a tremendous amount of transactions typically approaching Microsoft's year end because there's an urgency on their part to get deals done, and there's an incentive for our clients to cooperate with the timing priorities that Microsoft has established in terms of the negotiations. The other thing that I think is critically successful is that although Microsoft has a wide variety of licensing models to fit a vast array of business sizes and industries, that there are still unique issues that arise in each particular client's environment that should be negotiated as part of a transaction or as part of a resolution of a dispute. And knowing how to identify which of those provisions would be helpful to a particular company and going about obtaining those licensing concessions or provisions, I think is another one of the critical success factors that we see in terms of negotiation. Sometimes we see that our clients are creating problems for themselves. In many instances, the situation that they find themselves in with regard to a dispute or a transaction that may be going in a different direction than they would like is the result of certain things that they've done or failed to do internally that if they took care to avoid these pitfalls would put them in a much better negotiating posture. And the top one on the list that we've encountered just literally hundreds of times is reliance on an internal IT person or a vendor to interpret the contractual obligations with Microsoft. I would say that I wouldn't want an IT person to be charged with the legal responsibility of interpreting a company's legal obligations under a complex set of licensing rules. And those that do that, which there are many, usually wind up with some problems. The other one that we see a lot of is that many of our clients are buying through a reseller, either a large account reseller or a value-added reseller that has a relationship with Microsoft and is in a service relationship with the client, but in such a legal relationship where any representations or warranties made by the reseller will not be considered binding on Microsoft, because the agency relationship is not one where the reseller is acting as Microsoft's agent. So in many instances, either intentionally or unintentionally, a reseller may give a client certain advice regarding what software to purchase, only later to find out in a compliance review or an audit that Microsoft's interpretation of whether or not that particular software was appropriate would be different than the resellers, and Microsoft would consider itself not to be bound. So we tell our clients, when you're buying software, caveat emptor, or buyer beware, certainly is appropriate, and that you cannot rely on interpretations of third parties or non-binding licensing recommendations from Microsoft personnel that are not incorporated into binding amendments into the licensing terms. So that's a really big one. Another big one we see is consideration regarding licensing happening way after an environment has been constructed, such that you're faced with the dilemma of bringing the environment into license compliance or decommissioning or transitioning the environment. And we see that many clients have the common pitfall of failing to consider the licensing implications as part of the infrastructure planning and the project development. You should be looking at the various licensing options and the impact on licensing very early on. It should not just be a after-the-fact software asset management consideration, or even worse, something that only gets considered in an audit or a true-up scenario, but really moving that software asset management assessment early on, pre-procurement, is really the key to avoiding that particular pitfall. The other one that we see is just a gross misunderstanding of the virtualization rules, and we see clients that wind up with data centers that just are not properly licensed, where virtualization has, for lack of a better term, run amok, and there's really no clear understanding of how the virtualization rules work and the economics of those rules, and so you have an architecture that is really would not make sense if the economics and the rules were properly applied. One of the other things that we see in clients of all sizes is the inability to quickly understand what Microsoft software applications they have installed on their computers. It seems like it would be a very straightforward thing to do, and many of our clients have a number of tools that they've purchased with the hope that those tools would make this process easier. In many of our engagements, we're now taking disparate data feeds from a variety of tools that can be used around the world and trying to gather all of that data into an analysis, because the client has really no capability of understanding what software they have deployed. And I would say that the ability to do software discovery is a critical success factor. And if you have an organization that's flying blind on what's out there and what's being deployed, you are definitely going to be at a significant disadvantage in terms of your negotiations with Microsoft. Another common issue we see is that in order to reduce the cost of deploying new hardware and software, many customers have used software products like Semantic Ghost or other disk imaging capability software that basically puts out an image of software that may or may not be connected to the actual software that's being purchased with that hardware at the time that it's being purchased. So we wind up, particularly in the Office suite and in other suite products, with images that, for example, may have been burned down with Office Professional for end users that could do fine with Standard, for example. And so once those images are deployed, you've accessed the copyright for that product that's on the image, and you can wind up with a very significant compliance issue that can be expensive to resolve and or very time-consuming to remediate. The other thing that we see a lot of is just a complete misunderstanding of the direct and indirect access rules regarding Microsoft Server products. And even where there is an understanding, we see that clients are struggling with tracking the usage, whether it's over a Citrix environment, a remote desktop environment, a web type environment. There's so many ways now to remotely access Microsoft Server technology that it's just very difficult for clients to track that, and the cost associated with large-scale client access to servers can be extremely significant, and the inability to track that puts the customer at a very significant negotiating disadvantage with Microsoft. Sometimes the engagements that we work on go beyond just mere transactions and negotiations, but arise from license disputes. And I would say that most of our initial experience with regard to Microsoft licensing came from our involvement in dealing with these types of license disputes. And Microsoft has developed a pretty vast array of relationships in the marketplace through which they enforce their intellectual property rights, one of which is by offering a power of attorney to a trade group called the Business Software Alliance. And under that power of attorney, Microsoft has granted the Business Software Alliance the right to conduct on its behalf license enforcement in connection with self-audits that frequently arise as a result of a lead that is generated from a disgruntled employee or former employee, and in some instances based on the promise of a reward. In the past, as high as $1 million rewards have been offered to disgruntled employees and former employees who make anonymous tips to no piracy hotlines and or fill out web forms for purposes of prompting an investigation by the BSA, which in many instances will involve Microsoft software licensing. The Business Software Alliance generally is targeting small and medium-sized businesses. It's in the over 215 cases that I've handled. Rarely will we see a large enterprise customer. Rarely will we see a publicly traded company being audited by the Business Software Alliance. For the large enterprise clients, we're seeing more of the third-party audits. And in those situations, Microsoft has partnered with and retained the services of the leading auditing firms, namely Ernst & Young, Deloitte, and KPMG, that are out engaged in conducting compliance audits and partner audits under the service provider licensing agreement on behalf of Microsoft. And those audits are typically at the medium-sized to large enterprise client. They tend to be a little bit less adversarial than the agency-type audit, in that you're primarily dealing, the customer is primarily dealing with an accounting professional as opposed to a law firm on the other side. And they tend to be typically more involved and more collaborative in terms of the work than what's being done in a Business Software Alliance type audit. The Microsoft SAM engagement is another way that Microsoft has developed to create more visibility into what software licenses are being used in a particular client organization. They've developed what they refer to as the SAM ecosystem, which is a partner program where partners can become certified in Microsoft software asset management practices, and then can work with Microsoft on Microsoft's pay to assist Microsoft's customers with deploying discovery tools, calculating an effective license position, and then making a purchase of software that's necessary to deal with that. And the software asset management engagement is typically an optional program that's being offered by Microsoft. We have seen situations where clients have declined the SAM engagement without any problem and with Microsoft's blessing. In other situations, we've seen clients attempt to decline the software asset management engagement only to see threats of escalation toward legal or more formal audit arrangements. It begs the question of how optional the SAM engagement really is. And then, of course, if the audit that arises is not amenable to a resolution, then you have to look at the litigation considerations with regard to if the dispute can't be resolved out of court, then we'll look at what are the causes of action and the defenses, what are the probable outcomes, what are the other costs associated with litigation, and those are some of the issues that our clients are asking us to help them with. I will say that of all of the publishers, Microsoft is the most likely to do everything that they can to find a business resolution to a license dispute with a customer of any of the other publishers. I think that to say that their approach is to be litigation averse, I think is consistent with my experience. They certainly don't make a habit of suing their clients particularly over what would be unintentional license compliance issues. But that being said, they do have a very robust mechanism for dealing with and attempting to resolve these disputes. So in many instances, the question arises, what are the issues that come up? Why is a Microsoft negotiation or a transaction or an audit a legal issue? What is legal's involvement? And I think first and foremost, you're dealing with third-party intellectual property, and the implications for infringement of that third-party intellectual property can be very significant for a business. And so when we look at it in terms of basis for liability, we're focusing on what do the license agreements say, what are the licensing rules, and then we look at any use that's beyond those rules would fall in the area of a copyright infringement liability. So from a legal perspective, Microsoft is the copyright owner of the software products that it licenses, and it licenses them pursuant to licensing rules. We call them the licensing terms. And then anything that goes outside of those licensing terms would be a copyright infringement. And one of the things that we have to spend a lot of time counseling our clients on is the way that the burden shifts in a copyright case is different than the way the burden shift in criminal and other civil law matters. Namely, that in a copyright case, the burden is on the copyright owner to show that they have a copyright, and then it becomes on the alleged infringer, the burden then shifts to the alleged infringer to establish that they have a license. And so it becomes very important not to be relying on ambiguities or loose interpretations or a phone call, because from a legal perspective, the client will have the burden of showing the license. And so that's why I always like to help my clients interpret their licensing position applying Microsoft's interpretation of their rules, and then and only then looking at to what extent there may be legal arguments that suggest that a particular use is outside those rules, or that the applicable language may be subject to a different interpretation. But this copyright infringement issue related to software really is the core legal issue that we're looking at, and we're looking at it both in terms of damages, but also in terms of liability. And so one of the things that's important under copyright is that the Copyright Act under the Supremacy Clause does not basically trumps any state laws that protect individuals, or other successor liability rules under state law are not applicable to copyright infringement claims. So in many instances, for example, when we're working with a deal team to acquire assets, one of the things that we're carefully discussing with the customer is that part of their deal needs to be in the negotiation with Microsoft to make sure that the licenses that they're acquiring are amenable to transfer, and that they negotiate appropriate licensing terms before the transaction is final, because successor liability and copyright infringement liability will attach without regard to fault or knowledge, and as soon as you take possession of those IT assets. And so that's an important thing to think about. And I see a lot of my clients do the buy first, clean up later approach, which can be fraught with significant peril. The other thing that we're seeing, this is not as much of an issue with Microsoft, but I think it will be as time goes by, is that the Digital Millennium Copyright Act has a provision in it that deals with circumvention of access control technologies. So if you have people within your organization that are looking on the internet and getting crack codes and using product keys that are stolen, or otherwise making attempts to circumvent any kind of access control technology, that is separately actionable under the DMCA and is an area of significant legal risk that legal departments and lawyers should be thinking about, making sure that there are procedures in place to mitigate those risks. The other thing that we see a lot of is that on this point of Microsoft's urgency to resolve matters, one of the ways that they are able to move matters through to resolution is through a fairly complicated escalation procedure that they follow. And part of that procedure involves escalation of an issue that's not going well from their perspective to their internal legal department, also referred to as their LCA group, as well as escalations up into the C-level of a particular organization. So we have situations where if we'll have a gate on a time frame issue, and if there's not a resolution in that time frame, then Microsoft has a specific escalation procedure that they follow, which is part of the dispute resolution process. And the other issue that we come up with all the time is trying to help a client understand whether or not a audit resolution is appropriate, or does it make sense to consider litigation. And the reason that litigation considerations is so common is that frequently the client is trying to understand, is this a good deal? I've got this offer, and I want to understand, is this a good deal? Should I take it, or should I consider my next best alternative? And if you're down to the end of a negotiation, sometimes your next best alternative is to consider the prospects of litigation. Another thing that I think is very important to successful negotiation is managing an audit. I can't tell you how many negotiations I've been involved with after an audit has taken place where the parties are just in totally different universes about what's involved in the dispute and how it might be resolved. And I would say that following the steps of managing an audit correctly is critical, in my view, to getting a successful negotiation as part of an outcome. So negotiating on the front end can save you a lot of heartache on the back end. And the framework for the audit, I think, is very important so that everybody knows what to expect and who's going to do what, what's going to be involved in terms of scope, what kind of access there's going to be, what kind of resources are going to be allocated. All of these things are critically important, as well as legal housekeeping matters like negotiating the agreements on what the pre-audit agreement is going to look like, negotiating information sharing agreements, including confidentiality and 408. 408, for those of you who are not familiar with that terminology, refers to Federal Rule of Evidence 408, which deals with the use and admissibility of settlement evidence exchanged in connection with settlement negotiations. And so these agreements are typically entered into in a software license dispute prior to the information being shared regarding deployments and entitlements, so that the end user can share that information without fear that it would be used against them in court in the event that an out-of-court resolution is not possible. The other part of how to manage the disputes is responding to the threats of escalation. In my experience, I think in many instances, multiple departments are going to have to be involved, including leaders from the business organization, the legal organization, the IT organization, and the procurement organization, and making sure that those people are engaged and in communications with Microsoft, I think, is important. And how you deal with threats of escalation and actual escalation within Microsoft's organization can be a success factor in reaching a favorable negotiation. In my experience, the senior business executives always do a much better job of coming to a business resolution than the outside lawyers do. And I generally look at my role as facilitating those business discussions and assisting with strategy in those business discussions, and then making sure that they become documented in appropriate settlement agreements or license agreements. But I think it's very important that the business people stay engaged and aligned with legal and procurement on the negotiations. I mentioned this issue of time frame, which is one that I think is persistent, in universal truth in software disputes and audits, that the publisher always thinks that it's going too slow and the end user is not in a hurry. I think that applies with equal force to Microsoft audits of all types, and it's a factor that needs to be managed appropriately, both in terms of managing expectations as well as aligning the appropriate resources to hit the time frames that are agreed to. The other aspect of managing an audit is how will any compliance gaps be dealt with. If there is a need for remediation, will you be able to buy or uninstall for those gaps, or will there be an expectation of a compliance penalty? Often takes the form of a fine or a historical look back on maintenance, but understanding how the matter will be resolved up front, I think, is a critical success factor to having a successful negotiation on the back end of an audit. I would say that the most important thing that a lawyer can do in dealing with a licensing transaction or a dispute is to help the client understand what are the real dollars in controversy. And this, surprisingly, is more difficult than you might think, and is an area that we spend the vast majority of our time looking at the licensing installation information, looking at the entitlement information, characterizing the usage, looking at issues like downgrade rights, upgrade rights. All of these issues become very important, as well as the area where a lot of our clients are struggling, as I said before, is the ability to do the software discovery in such a way that you're capturing all of the licenses that are all of the facts that will become important to a licensing determination. Again, what we try to do is we try to use the same methodology that Microsoft would use, either if they were conducting it on their own or if they were using a third-party auditor. So we're trying to calculate for the client the licensing position that they would be in according to Microsoft's interpretation of Microsoft's licensing rules. And that way, we can then say, well, if we have issues with any of those interpretations, then we can put a dollar amount on what those disputed terms might equal. But in calculating a financial exposure, we think it's appropriate to calculate using Microsoft's interpretation. The other thing that we see, and this is for the lawyers that are on the call, a major mistake that lawyers make. I've been the second lawyer on many cases where the first lawyer made this mistake, which is producing audit materials or deployment reports or allowing an audit, a third-party audit to proceed without having an understanding of what the outcome is going to be. Because the client may be producing the audit materials with one understanding of what the exposure might be, and then when they get the response from Microsoft or the auditors as to what they think the dollars in controversy are, in many instances, if you haven't adequately prepared the client for that outcome, you're going to wind up looking very unprofessional and very unprepared, particularly if you're also surprised by the outcome. And I would say that that's something that you really want to avoid if you're counseling clients on these issues. The other thing that we find, and this is one reason that I'm against third-party audits, is that when the third-party auditor does the calculations, it puts the client in a very defensive posture of interpreting, challenging, trying to understand, trying to rebut the auditor's calculations. And so we find ourselves in many instances basically having to rework the audit through the process of challenging and verifying the third-party auditor's calculations. And getting into that pattern can be a significant problem for reaching a resolution. And so one of the things that I try to do with my clients that have received third-party auditor findings is to try to teach them to play offense as opposed to defense, to get into this defensive mindset where we consider the project to be one of challenging and correcting the third-party auditor's calculations, when we should be really thinking about a business proposal that deals with the dollars and the terms that we would be comfortable resolving the dispute on. And so for that reason, I generally encourage my clients, if at all possible, to avoid the third-party audits for that reason, because I don't think they're efficient or effective, and I think the self-audit is a much more successful approach. Unfortunately, the accountants and Microsoft don't always see the wisdom in that particular approach, and so there are still a number of third-party audits that we're dealing with, and we get into this pattern of reviewing their work and correcting, in many instances, issues that we think are appropriate to be revisited. The last part that we get to is, in many cases, as I said, the business people are involved, or the procurement people are ultimately involved in reaching some business terms, and then it gets kicked back over to the lawyers to document the findings. And one of the issues that comes up in settlement agreements is certifications and/or reps and warranties regarding current and past usage of the software, as well as reps and warranties regarding future usage of the software. And that's something that you want to make sure that you're looking at carefully to make sure that any reps and warranties or certifications are going to be easy to substantiate, and that people in the organization are comfortable making those reps. I would say the biggest issue that arises in Microsoft, either license transactions and/or dispute resolutions, is the nature of the release. Every software license agreement has the potential to contain a release in it. A release would be a provision that says that, for example, Microsoft agrees to release and hold the client harmless for any claims that it may have had prior to the time of entering into this settlement or license agreement. And I would tell you that Microsoft is not alone in terms of software publishers that are very loath to give releases regarding IP infringement. And yet, in many organizations, the release is a necessary provision in order to get senior management approval for the transaction. So we generally spend a lot of time negotiating the specific terms and scope of the release that will be contained in the agreement. The other thing that we think about a lot is the non-monetary provisions. Those could include, for example, what rights there will be to audit in the future, what is the effect of an over-deployment or an under-deployment in the future, what kind of what will happen in the future if the business suffers a downturn, what will happen if the business acquires assets or companies, and how will they be dealt with. So there's a number of non-monetary terms that we come up with, but I would say first and foremost, again, in many instances, the last provision that gets negotiated, which is the most important provision in many instances, is the release. I want to thank everybody for participating in the presentation today. This slide contains my contact information. I'd love to hear from you by phone. That 214-999-2902 is my direct dial here at my office. And or feel free to email me any questions or comments at rjscott@Scott & Scott LLP.